Hello viewers, I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. Today we will learn about the Federal Court. The objectives of the present module are: number 1, to discuss the establishment and composition of Federal Court in India during British rule. Then, to learn about the jurisdiction of the Federal Court and the procedure of enforcement of its decrees. Then, to explain the authority of the law laid down by the Federal Court. Dear learners, let's begin our discussion with a brief prologue of the topic. The Government of India Act 1935, which established a federal government with provinces as its constituent parts, was passed in India. The Act included a provision allowing native princely states to voluntarily join the federation. In a federal system, disputes may develop between the centre and the units, that is provinces, or amongst the constituent units themselves. As a result, the Federal Court of India was established and formally inaugurated on October 1st, 1937, and it served as the Indian judiciary's highest court until 1950, when the current Supreme Court of India took its place. In November 1934, the Joint Select Committee of Parliament recommended the establishment of the Federal Court of India. The Supreme Court of India, as we have it today, has its traces in the Federal Court of India. It was for the first time that a supreme body and a court of final appeals were established by the lawmakers in India. The jurisdiction of the Federal Court of India expanded from solving disputes between provinces and the federal state to hearing appeals from the high courts of all provinces. Apart from the Government of India Act 1935, the federal courts were also empowered by the Federal Court Act 1937. This act empowered the federal court to make rules and regulations to regulate the courts in India. The Federal Court continued to be the final court of appeals in India till 1950. When India attained independence in 1947, the Constitution of India was drafted and enacted in 1950. This also replaced the Federal Court with the present Supreme Court of India. The first sitting of the Supreme Court of India was held on January 28, 1950. My dear learners, let us discuss about the composition of Federal Court. As per the provisions of the Government of India Act 1935, the Federal Court consisted of a Chief Justice of India and not more than 6 puisne judges. Every judge of the Federal Court was appointed by His Majesty by warrant under the Royal Sign Manual and was to hold office until he attained the age of 65 years. It was further provided that a judge might, by his resignation under his hand addressed to the Governor General, resign his office. Also, a judge might be removed from his office by His Majesty by warrant under the Royal Sign Manual on the ground of misbehavior or of infirmity of mind or body if the Judicial Committee of the Privy Council, on reference being made to them by His Majesty, reports that the judge ought on any such ground to be removed. As far as the qualification of the judges of the Federal Court are concerned, they were: number 1, he had been for at least 5 years a judge of a high court in British India or in a federated state, or he was a barrister of England or Northern Ireland for at least 10 years of standing, or a member of the Faculty of Advocates in Scotland of at least 10 years standing, or he had been for at least 10 years a pleader of a high court in British India or in a federated states, or of 2 or more such courts in succession. In case of the Chief Justice of India, a person was not qualified for appointment as Chief Justice of India unless he was a barrister, a member of Faculty of Advocates, or a pleader, and he had been for at least 15 years a pleader of a high court in British India or in a federated states, or of 2 or more such courts in succession. Dear learners, it is pertinent to note that the judges of the federal courts were entitled to salaries and allowances, included allowances for expenses in respect of equipment and travelling upon appointment, and to such rights in respect of leave and pensions as fixed by His Majesty in Council. There was provision for temporary appointment of acting Chief Justice. If the office of Chief Justice of India became vacant, or if the Chief Justice is by reasons of absence or for any other reason unable to perform the duties of his office, those duties were to be performed by such one of the judges of the court as the Governor General in his discretion appointed for the purpose. The seat of Federal Court. The Federal Court was a court of record and sat in Delhi, and at such places or places, if any, as the Chief Justice of India might, with the approval of the Governor General, from time to time appointed. Dear learners, now we will discuss about the jurisdiction of Federal Court. The Federal Court had original, appellate and advisory jurisdiction. Firstly, original jurisdiction. The Federal Court exercised an original jurisdiction in any dispute between any 2 or more of the following parties. Number 1, the Federation and any of the provinces. Number 2, any of the federated states if the dispute involved any question, whether of law or fact, on which the existence or extent of a legal right arising out of the interpretation of the Act or the legislative or the executive authority vested in the Federation by the instrument of accession or an agreement under Part 6 of the Government of India Act 1935 in relation to the administration of a federal law. The Federal Court, in the exercise of its original jurisdiction, was to pronounce a declaratory judgment. Secondly, the appellate jurisdiction of the Federal Court. The appellate jurisdiction of the Federal Court extended to the appeals from any judgment, decree or final order of a High Court in British India. If the High Court certified that the case involved a substantial question of law as to the interpretation of the Government of India Act 1935 or any order in council made thereunder. Where such a certificate was given, any party in the case may appeal to the Federal Court on the ground that any such question as aforesaid has been wrongly decided, and on any ground on which that party could have appealed without special leave to His Majesty in Council. If no such certificate has been given, and with the leave of the Federal Court on any other ground, and no direct appeal shall lie to His Majesty in Council, either with or without special leave. In the later years, the federal court criticized certain high courts for granting certificates in instances in which the federal court believed that certificates should not have been issued. In JK Gas Plant Manufacturing Company, Rampur Limited versus King Emperor, a case of 1947, it was emphasized by the federal court that a certificate should not be issued unless the appeal was in fact from a judgment, decree or final order. That is, unless the decision of the High Court was a final determination of the rights of the parties. Section 207 of the Government of India Act 1935 empowered the federal court to hear appeals from the High Court in exceeding states on questions relating to constitutional matters. It is worthwhile to note about the power of federal legislature to enlarge appellate jurisdiction. Under Section 205 of the Federal Court Act 1947, the federal court was empowered to consider appeals which were competent without any such certificate from the High Court. However, no appeal could lie unless the amount or value of the subject matter of the dispute in the court of first instance was not less than 50,000 rupees. Secondly, the federal court gave special leave to appeal. Dear learners, now I will throw light upon the appellate jurisdiction of federal court in appeals from high courts in federated states. An appeal lied to the federal court from a high court in a federated state on the ground that a question of law had been wrongly decided, being a question which concerns, number one, the interpretation of the Government of India Act 1935 or of an order in council made thereunder, or the extent of the legislative or executive authority vested in the federation by virtue of the instrument of accession of that state, or arose under an agreement made under Part 6 of this Act in relation to the administration in that state of law of the federal legislature. Moving further, another point is regarding the appeals to His Majesty in Council from a decision of federal court. An appeal might be brought to His Majesty in Council from a decision of the federal court on the following grounds. Firstly, from any judgment of the federal court given in the exercise of its original jurisdiction in any dispute which concerns the interpretation of this Act, or secondly, of an order in council made thereunder, or thirdly, the extent of the legislative or executive authority vested in the federation by virtue of the instrument of accession of any state, or fourthly, arose under an agreement made under Part 6 of this Act in relation to the administration in any state of law of the federal legislature without leave, and in any other case by leave of the federal court or of His Majesty in Council. Dear learners, let us learn about what was the form of judgment on appeal. The federal court, where it allowed an appeal, remitted the case to the court from which the appeal was brought, with a declaration as to the judgment, decree or order, which is to be substituted for the judgment, decree or order appealed against. and the court from which the appeal was brought shall give effect to the decision of the federal court. Where the federal court upon any appeal made any order as to the cost of the proceedings in the federal court, it, as soon as the amount of the cost to be paid was ascertained, transmitted its order for the payment of that sum to the court from which the appeal was brought, and that the court had to give effect to the order. The federal court was empowered to impose such terms or conditions as it may think fit to impose, order a stay of execution in any case under appeal to the court, pending the hearing of the appeal, and execution was to be stayed accordingly. My dear fellows, let's discuss about the advisory jurisdiction of the federal court. Section 213 of the Government of India Act 1935 empowered the federal court to give advisory opinions to the Governor General. The Governor General was not bound to accept the opinion of the federal court, which was given under section 213. Moreover, the court was not bound to give its opinion in every reference made to it. The real intention of this provision appears to be that the federal court would not refuse except the good reasons. The federal court was called upon to give its advisory opinion in 4 cases, and in each case it gave its opinion, but not without expressing on occasion some misgivings about both the expediency and utility of this consultative role. Regarding the enforcement of decrees and orders of federal court, the Government of India Act 1935 mandated that all authorities, civil and judicial, throughout the Federation should act in aid of the federal court. The federal court, in respect of British India and the federated states, had power, firstly, to make any order for the purpose of securing the attendance of any person. Secondly, the discovery or production of any documents, the investigation or punishment of any contempt of court, which any High Court in British India had power to make as respects the territory within its jurisdiction. Also, any such orders as to the cost of and incidental to any proceedings therein. Another highlighting point is letters of request to federated states, where in any case the federal court required a special case to be stated or restated by, or remitted a case to, or order a stay of execution in a case from a high court in a federated state, or required the aid of the civil or judicial authorities in a federated state, the federal court caused letters of request in that behalf to be sent to the ruler of the state, and the ruler caused such communication to be made to the High Court or to any judicial or civil authority as the circumstances may require. Law declared by federal court and Privy Council was to be binding on all courts. Section 212 of the Government of India Act 1935 provided that the law declared by the federal court and any judgment of the Privy Council would be binding in all the courts in British India. It introduced the English doctrine of precedent in India. Thus, the high courts and the subordinate courts in India were absolutely bound by the decisions of the Privy Council and the federal court. power of Governor General to consult Federal Court. The Governor General was empowered to consult the Federal Court if in his opinion a question of law arose or was likely to arise, which was of such a nature and of such public importance that it was expedient to obtain the opinion of the Federal Court upon it. He may, in his discretion, refer the question to that court for consideration, and the court may, after such hearing as they think fit, report to the Governor General. The Federal Court had to deliver its opinion in open court, with the concurrence of a majority of the judges present at the hearing of case. Furthermore, a judge was free to deliver a dissenting opinion. With regard to the rules of the court, the Federal Court was empowered to make rules of court with the approval of the Governor General for the following purposes. Number 1, for regulating the practice and procedure of the court, or rules as to the persons practicing before the court, or rules as to the time within which appeals to the court were to be entered. With regard to the costs of any incidental to any proceedings in the court, and as to the fees to be charged in respect of the proceedings therein. Then, the rules providing for summary determination of any appeal which appeared to the court to be frivolous or vexatious or brought for the purpose of delay. Also, rules to fix the minimum number of judges who are to sit for any purpose, and that no case should be decided by less than 3 judges. The Federal Court delivered all the judgments in open court, and with the concurrence of a majority of the judges present at the hearing of the case. All proceedings in the Federal Court were to be in the English language. Ancillary powers of Federal Court. The Federal Legislature was entitled to make provision for conferring upon the Federal Court such supplemental powers not inconsistent with any of the provisions of the Government of India Act 1935, which appeared to be necessary or desirable for the purpose of enabling the court more effectively to exercise the jurisdiction conferred upon it. Expenses of Federal Court. The administrative expenses of the Federal Court, including all salaries, allowances and pensions payable to or in respect of the officers and servants of the court, were to be charged upon the revenues of the Federation, and any fees or other money taken by the court formed part of those revenues. What was the form of judgment? The Federal Court of India, as provided by Section 209 of the Act of 1935, had no machinery of its own to execute its judgment. It was sending back the case with its decision to the respective High Court, so that its order could be substituted for the order of the High Court. The provisions of Section 209 were amended by the Privy Council Abolition of Jurisdiction Act 1949. Its effect was that the Federal Court's orders were made enforceable in the manner as provided by the Civil Procedure Code or by any other law which was made by the Dominion Legislature. What was the authority of law laid down by Federal Court? Section 212 of the Government of India Act 1935 provided that the law declared by the Federal Court and any judgment of the Privy Council will be binding on all the courts in the British India. It introduced the English doctrine of precedent in India. Thus, the high courts and the subordinate courts in British India were absolutely bound by the decision of Federal Court as well as the Privy Council. When the Constitution of India was enacted in 1949, Article 374 Clause 2 was inserted with a view to settle the position regarding the authority of law laid down by the Federal Court. Article 374 Clause 2 states that all suits, appeals and proceedings, civil or criminal, pending in the Federal Court at the commencement of this Constitution shall stand removed to the Supreme Court, and the Supreme Court shall have the jurisdiction to hear and determine the same, and the judgments and orders of the Federal Court delivered or made before the commencement of this Constitution shall have the same force and effect as if they had been delivered or made by the Supreme Court. My dear learners, in the last but no way the least, it is submitted that post-independence in 1947, the Constitution of India came into existence. In 1950, this also replaced the former Federal Court with the present Supreme Court of India. The newly formed Supreme Court held its first sitting on January 28, 1950. The Supreme Court was given the same powers as the Federal Court had, and the decisions of the Supreme Court became binding all across India. The Supreme Court also acts as a court of record through the provisions of Article 129 of the Constitution. With this, we conclude this lecture. I hope you find this lecture informative and insightful. Thank you very much.